which he was successful, he called experts from the art community to talk about how indeed his artistic reputation was likely to be damaged by the association with the decorated version of his work. The judge was persuaded, and the order, of course, was to remove the ribbons forthwith. Now, though, we're seeing a very interesting legal movement in Canada, which is more interest in the area of moral rights, more litigation, reaching now up to the Supreme Court level, and a problematic issue, a split at the Supreme Court between English and French judges. And the legal issue on which all of this is turning seems quite arcane at first. It has to do with the relationship between economic and moral rights. And basically the question is, are they two sides of the same coin, or are they two distinct families of rights on their own? And there are actually two names for these schools of theory, one being the monist approach, which is two sides of the same coin, the other being dualist, which is the split between the two branches. And again, it seems like a fine point of theory, but it has very important practical implications. So in France, the way that we get perpetual protection for moral rights is through a dualist system, because economic copyright has to be time limited, but the moral rights are potentially free form, and so they're allowed to persist forever within the French copyright law. So duration is affected by that theoretical point. Now, legal systems may not always be entirely clear about the doctrinal basis of their protection for moral rights. They might have a hybrid or mixed system. That's somewhat the case in both India and Russia, as hopefully we will see. But in Canada, what we really have is confusion. And the confusion has turned on this particular issue. Do we have a monist or a dualist approach in our legislation? Or, alternatively, but we haven't quite got there yet, eventually, do we want to forge a mixed approach? Now, we do have a monist system in the sense that duration of moral rights is limited, so it lasts as long as copyright and no longer. But in a 2002 Supreme Court case called Théberge versus Galerie d'Art du Petit Champlain, the Supreme Court seemed to reject this monist theory. When it did so, it took the existing dualist theory and turned it completely topsy-turvy. So, as I've already suggested, the traditional meaning of dualism is more extensive protection for moral rights than for economic rights, because it's a natural rights theory. But in Canada, when we espouse a dualist theory, we mean that we give less protection to moral rights than to economic rights. And then to confuse matters further, in 2003, the Supreme Court had another ruling, and it made an off-the-cuff remark that actually Canada is governed by monist theory. So what happened in Théberge that gave rise to this debate? The case had to do with reproduction of an artwork. And what essentially happened was Claude Théberge is an artist, a painter, who authorized the making of a number of souvenir items associated with his work, so postcards and other works of that kind that would reproduce his original images for the purpose of souvenir sales. And what eventually happened was that another company came along and decided to make canvas-backed reproductions of his work. What they did was to take a postcard, lift the ink from the postcard, and superimpose that image upon a canvas. So note that in this process, there's only one copy of the work at any given point in time. Okay, the postcard exists at the beginning, the canvas is blank. At the end, the canvas bears the image, the postcard is blank. Believe it or not, that is actually the key factual issue on which the decision turns. So the artist actually gave evidence that he wasn't especially concerned about the commercial consequences of these new canvas-backed reproductions. What he was worried about was his reputation. And he felt, presumably, that people would be confused when they saw those canvas-backed works and think possibly that they were original works by him. When the Supreme Court considered the case, it came back and said, the majority, I should say, said that no reproduction had occurred. The reason being that there was one copy at the beginning, one copy at the end, and that multiplication of copies is really what defines reproduction. One of our outstanding judges actually gave that judgment, Justice Binney of the Supreme Court of Canada. What he said was that Théberge was doing something a little bit underhanded. He was trying to make a moral rights claim about his reputation while framing it as an economic rights complaint. And Justice Binney said, well, you can't do that because there's a different standard of proof that applies to moral rights claims. You know, when it comes to copyright, any unauthorized act by definition is a violation of copyright. But as we've just seen in those few examples, when it comes to moral rights, usually you have to prove that there has been some damage to your reputation before you have a right to complain. And so Justice Binney said we have to be very careful. We have to protect that extra standard of proof when it comes to moral rights in Canada. The dissent for all of the French judges on the court, written by Justice Gontier, he said, well, this is not a case about moral rights. Reproduction has occurred, and what matters is not the number of copies that exist, but the number of times the transformation of that particular work occurs. Again, here clearly there have been 2 attempts to create copies of the work, so clearly it's a case of copyright infringement. He says what we must count in order to determine whether a work has been reproduced is not the total number of copies in the work, but the number of materializations that occurred over time. Split, English judges for the majority, a victory of 1, all of the Francophone judges on the minority. So it just remains to be seen how influential that decision is actually going to be, whether the majority or the minority view persists in the future. Let's turn to India, which I think will be the conclusion of my remarks today. Sorry, we don't have time to get to Russia because it's a fascinating example of moral rights also, but perhaps in the questions if we have time for those. In India, we had a leading moral rights case in 2005, and that case turned on the issue of how to recognize a copyright work as an important part of a nation's cultural heritage. And you can think of it as a sort of life cycle question. It's a distinction between intellectual property and what eventually becomes cultural property. So something might be created at some point in time. At that point in time, it's a work of individual authorship or group authorship potentially. It's a work created by identifiable authors. And that is the definition of a copyright work. When the author dies, a transitional movement is initiated. So it continues to be intellectual property for a period of time for the duration of copyright protection, 50 or 70 years after the death of the author. But there's no living author to take care of it, so it's in charge of the heirs or whoever has inherited the rights of action. Finally, after the term of copyright protection expires, the work falls into the public domain. And at that point, it becomes cultural property. So its connection with the specific author will be more remote. But on the other hand, as the judges in this case pointed out, its connection with a community or country may be stronger than ever. We have different legal frameworks governing cultural property and intellectual property. Intellectual property, private rights, private property rights. On the other hand, cultural property, it's a framework of public international law conventions. So a completely different legal theoretical framework for both forms of rights with, as usual, practical implications. In the case of Amarnath Sehgal versus Union of India, Mr. Sehgal, seen in this picture with then Prime Minister Nehru, was a sculptor of great national and international renown, and he was asked to design a sculpture for a public building in New Delhi at a time when Nehru wanted to encourage Indian artists to showcase the culture and revive the pride of the country after the colonial occupation. And in fact, here we see the sculptor visiting the actual work of art when it's been placed on the wall, that mural in the background with Pandit Nehru. So he completed the work in 1957 for the august sum of 300 rupees. But the work came to be considered a national treasure of India. But in 1979, the mural was actually taken down by the government of India for the purpose of storage. And when they did so, they damaged it because of improper transportation and storage. Sehgal, very upset about this, so he applied for an injunction to prevent further damage, which was granted in 1992. That shows you how the Indian legal system works. Okay, and eventually in 2005, so some nearly 30 years after the litigation was first brought, he won damages in the case. But what happened between 1992 and 2005? Well, the Indian government decided that a reform of moral rights was due. This is because the original scheme from 1957, as I alluded to earlier, contained a very broad statement of the moral right of integrity. It said that there was no requirement for damage to reputation, and there was no specified duration, leading to the possibility that moral rights in India could last forever. And sure enough, in the interim ruling, the court had a very sympathetic view of the author's situation, and it imposed a duty of care on the Indian government to deal with works in its custody. The Indian government, I think, became very nervous about this ruling and introduced amendments which came into effect in 1994. Those amendments redrafted the integrity right to match the limited formula in the Berne Convention, where author's reputation was required, and it also created limited duration for the protection of moral rights. So how did the judge address all of these issues in 2005? He had a few choices. He could have said, for example, that the old provisions continue to apply because the damage occurred at a time when they were in force and because that was when the suit was brought. Or he could have said that the new provisions apply because clearly there was a change in policy that was intentional on the part of the Indian government. Now, in the event, as judges do, he did something completely different. He made 2 points. The first was that it didn't really matter in this case whether we took the old or the new versions of the provision, because destruction of a work of art, which is what was at issue here, does affect the reputation of the artist. It damages his overall creative corpus. So the idea of destruction was affirmed by the judge as part of what is covered by the right of integrity. And he then goes on to say that in the case of outstanding works of art, it's not only the intellectual property framework that applies, but it's also the cultural property framework that applies. So there's an overriding obligation derived from cultural property principles to protect the integrity of the work. And to go back to my point, it doesn't really matter whether it was the old or the new provisions, because the cultural property obligations of India require us to read those provisions as if they were the old ones, to put it in a very lawyerly framework. And so he says, the various declarations by the international community in the cultural property conventions noted above lift the moral rights in works of art if the same acquire the status of cultural heritage of a nation. India is a signatory to the conventions, and it would be the obligation of the state to honor its declarations. So in other words, interpretation of the moral right is colored by the recognition of cultural property belonging in this case to the nation or the country. And that has to be the context in which any legal provisions on moral rights are interpreted in India. So unfortunately, we don't really have time to go into Russia, but as I said, there are many interesting things to discover in the experience of Russia and other post-socialist countries about the relationship between copyright, moral rights, and free speech. I will just conclude by remarking that I hope this quick survey has helped everyone to see that difficulties in implementing moral rights are not unique to the United States by any means. These are difficulties that are faced by common law countries everywhere, even in a context as culturally removed as that of India. But I hope you're also persuaded that recognition of moral rights in such a variety of jurisdictions is a persuasive argument that they're worth looking into. And the goals that are pursued through moral rights in those environments do reflect interests that are likely to grow in importance in the digital age. Concerns such as the preservation of cultural heritage in the case of India, historical truth and the human rights of creators in the case of Russia and post-socialist countries. I think that given the exceptional democratic heritage of the United States, these are worthy goals to pursue through the US copyright and moral rights provisions. So thank you very much for your patience.
And I hope you're also persuaded to go out and buy her book, which she's plugging back here very, very subtly. In the interests of time, I think we won't do a Q&A session here, but we do have a reception just outside for anyone who'd like to stay and ask Mira questions about Russia or about her presentation. You're all welcome, and we'd love to see you around there in a few minutes. Thank you all for coming, and thank you very much, of course, for presenting. Okay.